Thank you once again for joining me at Dialogues with Jagero. We have been running a series. We are going to call it now with Christine Muthoni, a divorce lawyer. And we have talked about divorce. We have talked about wealth distribution in case a marriage dissolves or dissolves itself. Now we are going to go to one of the things that is on people's minds. That is, where do my children go when this marriage comes to an end? What happens to their upkeep? Is that the word? Upkeep, right? So Muthoni, thank you once again for allowing us to do this series with Dialogues with Jagero. I'm really enjoying it and learning. I'm a student of learning. So we are talking about children at that juncture when marriage is dissolved. You know, where do we start? You told me something that you can actually do this at the prenup level, and generally give a roadmap and agree on a roadmap of what happens when the divorce comes to an end, how the upkeep is going to be done, and who holds the right to stay with the children. I don't know, the lingo is who does custody over the children. Yes. So probably you could just tell us how it happens at prenup, how it should happen at prenup, and now if it doesn't happen there, how does it now start? Yes. I remember also, don't forget to tell us that the divorce starts and then something follows and then something follows. Yes.
All right. This is one of the topics I'm so passionate about. I love it so much. So I'm happy to be here doing this series with you. Now, there are two types of custody. There is physical custody and legal custody. Legal custody is to do with decision making about the children. This one is major decisions. And then there is physical custody. Physical custody is actually living under the same roof with this child. When this child goes to school, they come back to your house where you are. That's physical custody. So if you got into this marriage consciously and you thought about the terms and conditions, how you're going to conduct yourself in the marriage, and in case it ends, then you could also discuss about custody of the children and support in case divorce comes up in future. Legal custody is actually conferred upon you by the law. Yeah, you have legal custody over your biological children, and you can acquire it if they're not your biological children through adoption. But as long as you're the biological parent, you have that automatically. Physical custody is you two to decide, and this decision will be made in the best interest of the children. If the children are with the mother, are they better off than when they're with the father? This is something you can decide for yourself. But if you're not able to decide for yourself in advance or at the point of separation, then you have to go to the children's court to decide for you. Normally, a woman walks out with her children. That is what is most common. She goes with the children and the man is left without the children. So he'll go to court and ask for access and visitation, or ask for custody if he feels he can be able to live with these children and take care of them, and it is better for the children to be with him than with their mother. Or the mother goes to court and says, I need child support. We did not prepare for this. We didn't see it coming. The marriage was not working. I left and I took the children, and now I'm struggling to take care of them. My finances are not that good. So when she applies for child support, then her husband is served with those, her ex-husband is served with those documents, and he has to respond to them. Sometimes, or rather most of the times, they also ask for access and visitation. Yes, you're asking for child support, but I also want to see my children and have access to them. Then the court decides. Normally you'll be given, legal custody will vest on both parents, and then physical custody, care, and basically living with the child will be with the mother if the children are below 18, and especially if they are of tender years. However, this is not obvious that the custody will be given to the mother. Nowadays, fathers are also being given physical custody. The same way a woman can take care of her children, a man can do the same as well. Some will argue that a man doesn't have he can't nurture, he doesn't have that nurturing characteristic, or he has to go out and work and make money. But in today's age, it's the same with women. They also go out to make money. Who do they leave these children with? House helps. So the same way the man is going out to make money, he'll also leave the children with house help. The problem comes whereby the man gets physical custody but takes them up country to live with his mother. Yet the wife is here, she's able-bodied, she can have custody. All she needs is just a little support financially. Yeah, so assuming you had not prepared for all this, you will file for divorce, and then you can file for the children's, you can file the children's matter simultaneously with the divorce. If a client comes to me and tells me, I want you to handle all this for me, I will not automatically file in the children's court. I'll automatically file the divorce, but call for negotiation with the other party for us to come up with an agreement, which we call a parental responsibility agreement, which will be majorly decisions made by these two parents about how they want to co-parent. My client will be relying on me to look out for her interests and the child's interest as well. The man may get his own lawyer to look out for his interests and the child's as well. But at the end of the day, the deciding factor should be the interest of the child. And the best interest of the child is not decided by convenience on the part of the parents. It is actually decided by what is good for the child. Because you may find sometimes a woman is very upset at the husband because of the reasons why they are divorcing, and she genuinely feels that the children will not be safe with him. So she will present her reasons as to why to me. This is before we even go to court. And while she's presenting those reasons to me, the man is there and the lawyer. These are genuine concerns we can discuss. We will discuss them and see how to iron them out. If they can be ironed out and now she's comfortable giving access to the man, then now we put it in writing. And she says the responsibilities she will take care of, because it's 50-50. It's not the man to provide everything. It's actually 50-50. But when we are deciding, you know my finances, I know yours. You can actually decide to do 100%. It's okay. Then we go to court and we have it adopted as an order of the court. And now when it's an order of the court, there are consequences for not complying. However, if we cannot sit down and discuss because maybe the divorce is very acrimonious and we are also declaring matrimonial property on the other side and things are really bad, so we don't want to discuss anything, we just go straight to court. And when we go to court, the court will decide based on the information you provide to the court. Sometimes the court will also require some information from a children's officer. So they say a report to be filed. So the children's officer in your area will visit you and visit the mother and file a report, which will help the court to decide on whatever decisions it needs to decide on, depending on the prayers that have been prayed by both parties. And at the end of the day, if the man is asking only for access and visitation, he will be granted. It could be granted unlimited access, or it could be granted structured access. And if it is structured, it's up to the court to say, every other weekend, or every weekend, or every whatever.
Access here means that I can also the man or the spouse that is not living with the kids at the time can pick those kids and go wherever they want. They can go eat pizza, they can go to a swimming pool, they can go for a picnic outside town. Basically, when you have access to the children, you have the children in your custody, so to speak, within that period of time.
Yes, that is unlimited access.
No. You have told that it is structured still.
No, there are two, limited and structured.
Yes, but we are talking.
Yeah.
I'm asking about structured. You have been told that you can only access your kids on the weekends. That is on Saturday and Sunday.
Yes.
Can I pick them on Saturday morning and go with them to a picnic in Nyahururu,
Yes.
you know, and then bring them on Sunday?
They are yours. If Sunday is your day, and you have been told you will take the whole day with them, take them wherever you want to take them. You are equally a parent to them, you know. But if the mother has some reservations, which she'll have to substantiate, she can present them in court and ask for supervised visits or limited time. So you can be told you'll only meet these children for 3 hours on Sunday, and you'll meet at this place. You're not allowed to take them to your house or wherever. So if you cannot decide this for yourselves, then the court will decide for you based on the information you've provided. But it's always best for the parents to just agree and tell the court, this is what we have agreed. So the court is just helping you to legalize that consent. Yeah, so the judgment will be entered by consent. Or your PRA, which is now the parental responsibility agreement, will be adopted as it is. And it is you who has made all those decisions there with the help of your lawyers. But if you want full custody, physical custody as a man, you can still get it, apply for it. Though if the children are young, then it may be a bit more difficult for you to get.
How young are we talking about?
Let's say 10 years and below, and they are girls, or tender years are the small ones, those ones who are toddlers and what have you. But young, 10 years below, big ones who can speak for themselves, preteens and teenagers, you can get custody very easily, depending on a few things. Like, for example, if the mother is agreeable, that is the best way for you to get physical custody. If she's not agreeable, now you have to tell the court why you're taking these children from her. Perhaps she's a drug addict and she's been to rehab, or she's still going to rehab, or maybe she has some psychological, mental issues and she's getting treatment for them, or maybe she's a drunkard who's not seeking rehabilitation, she has not accepted, she's in denial, or something of the sort. Show that she doesn't have the capacity to provide what the children need from a parent, and you do. You will be given. But her being broke is not ground enough for you to get full physical custody.
Do people go and say that this one hana mbele wala nyuma?
Exactly. There are people who go and say, you know, I've given these children this kind of lifestyle, but if they go with the mother, they will have a lower standard
of living.
Know? Yes, and I don't want that for my kids. You know, she's now my ex, so I don't care if she has that lifestyle. But because she's with my children, I don't want my children to have that lifestyle. So I want physical custody. If that is the only ground, then it might be tricky, because why don't you give her child support?
Since we started talking, Christine, there is something that I'm seeing that is particularly very specific to Kenya and not found. If you read the stories coming from abroad, most of the time the man moves out, leaves the matrimonial home with the kids and the wife, the ex-wife. But it appears to me, the way you're talking, I don't know if it's right, that the women leave.
Yes. I think that's a cultural thing, because anybody who wants the best for their children will look at the circumstances as to why the marriage has failed and say, okay, it is easier for me to leave this home, because if I leave, they will stay where they are used to. The schools are near home. They will not be inconvenienced that they'll have to transfer. I will continue paying the school fees. Whatever has happened between me and their mother should not affect them. And you'll pick your bags and go. But what I've noticed here, I don't know if it's, I don't know what to say, but most of the time, people forget about their children and what is in the best interest of the children. You'll find, if the reason, for example, the marriage is not working is maybe domestic violence, you'll find that it is the wife who's being battered most of the times. Men are battered too, but most of the time it's the wife. So the wife will not come and tell the same abuser, leave. That's another war. It's easier for her to run for her life. And a mother who loves her children will not run from the war zone and leave her children in the war zone. She'll go with them. So after she has left the matrimonial home, wherever she has gone, she has taken the children, whether it's a better environment or it's a worse environment. If these two people had actually sat down before all this, come up with a prenup and discussed about not just the property but also how they'll co-parent, you'll reach that point where you say, this marriage is not working. Let us dissolve it and let's put into effect the agreement that we made while we were still in good terms. So I will pack my bags and leave, and I will continue. If it's a rented house, I'll continue paying rent as I have been doing, if it's the man who's been paying. If it's school fees, I will continue paying the school fees as we had agreed, and anything else that the children may need. The beauty about making these agreements is that you can also include your wife in that post-divorce support. In court now, they call it alimony. You can also give her alimony. So this is alimony for you to take care of yourself. I want the mother of my children in her best state so that she can take care of my children. And this is child support. So you're giving her all that and you leave. But that doesn't happen here. It's a cultural thing. But it can happen if you want it to. It's up to you. I always say that marriages are between two people, you and your wife. Don't say that the law says this or the church says this or my parents say this. It's you. You can craft it the way you want it, the marriage itself and post-divorce, the co-parenting. And I think that is always the best way to go.
Yeah. So then when we, child support, how, I remember before, I think they changed the law. Before that, I hear that one spouse would just come and say, okay, these are the bills. My daughter is going to Riara, the other one is going to St. Mary's, the other one is going to whichever school, to Breban. And these are the school fees that is supposed to be paid every term. And the man has to, they both have to agree. I think before it was the breadwinner that was mostly the man to cater for these bills, and it was just like, this is the bill, the rent is this much, and this is how it works. The man is saying, okay, I can see that you are having another man in that house, but you are giving this bill as the rent. Why am I paying rent for another man in that house? So I think, but then I think that the court wouldn't listen to that. They will say, okay, this is what you have to pay. These are the bills, bro. This is what you pay. And then I think they changed it to say that now the man has a say on where the child is going to school. So can you differentiate between the old law and sort of the new law? Yeah.
Okay, right now we are using the Children's Act of 2022, but as typical of many of us, we rely on hearsay.
Yes.
We read social media and we assume that that is what the law is. There is nowhere where the man will be forced to take 100% responsibility, even in the past, because even in marriages, it's not sustainable. People help each other, yeah? In middle class families, people help each other. So if you've been helping each other with bills, there's no court that will come and say, now the man will take 100% responsibility. No. Parental responsibility is 50-50.
Has always been 50-50.
Yes. And that means, but this 50-50 is not exactly 50-50. That's just what the law says. But the responsibility is encompassing financial and non-financial. And there is no court that will tell you school fees is 100,000, you pay 50,000 and you pay 50,000. No. What the court does is it looks at the basic needs of the child, and the basic needs are stipulated by the Children's Act. And this is food, clothing, shelter, medical, and education. Those are the financially quantifiable ones. And there's a sixth one, which is the care, love, guidance. So we'll only talk about the ones that are financial or financially quantifiable. Yeah. You will be told to select out of these 5 which ones you will take care of and which ones your spouse will take care of. If you cannot select between the two of you, because you're the ones who know how much you earn, yeah? If you cannot select, then the court will determine for you, depending on your affidavits of means, which you will be told to file. This is an affidavit that shows your income and your expenses, and you can also add your other responsibilities in that affidavit. Like if you have other children that you're taking care of out there, that will be factored in. So the amount of money that is left, your child will have to fit there, or your children will have to fit there. If they were going to Braeburn and now the income is not sufficient, downgrade to a school that you can be able to afford, the two of you. Well, the court normally gives school fees to the man, the father, and school-related expenses, meaning if there is school transport, extracurricular activities, uniform, things like that, that is given to the father by the court. He's also given medical. Medical, he can take an insurance cover, inpatient or outpatient or both, and it's more convenient to give the card to the mother because she's the one who is living with this child. There's no need to, start calling somebody at midnight, the child is sick. Huh? Or if not a cover, then the mother will cater for the emergency medical expenses and get reimbursement in hospitals that they have agreed. Because you cannot just...
So there are a lot of agreements.
There is a lot to be discussed. We go down to the nitty-gritty details of where will the children spend their birthdays, things like that. And then the mother will be given shelter, because it's not fair for the father to be asked to pay for her shelter, yet he's not living in that house. Yes, he's providing shelter for his children, but he's not living in that house. And the woman may move on, She can have all kind of visitors in that house, including men. How will this man feel? He's paying rent and there are other people he may not be happy going to that house. And maybe even him himself is not allowed to go there. So she pays for shelter and everything that comes with the shelter, which includes the utilities, water, electricity, internet, maybe nanny and things like that. And then clothing the mother. Although it is the joy of every parent to, buy clothes and shoes and nice things for their kids, you can buy, but the law will usually give clothing to the mother. You're the one with the children. You're the one who is seeing they're outgrowing their shoes, buy. And the father will be buying the uniform and school-related, expenses. And then you go with that. That is a bit risky sometimes because the court is making decisions for 30 matters. They're not going to go into the details of how able are you. Yeah. So if you're given school fees as a father and your child used to go to an expensive private school, but after divorce, you separated, you got another child out there, you're taking care of another child you had out there, maybe the other woman you got had other children, you've taken that. Your responsibilities are so much, you cannot be able to afford that expensive school. You used to pay for the children you had with your ex-wife. However, she's doing very well. She can be able to pay, but she will not pay because the court order says the father to take care of school fees. What's going to happen? You will downgrade because the parent who is given that responsibility has the final decision making of this child will go to which school. You'll not be forced to take your child to a school you cannot afford to pay. But if you can see the child is here, we want the best interest for the child, then you as the mother can take that responsibility.
Or you can chip in.
Yes, you can.
So, for example, this gentleman is saying that, okay, I want to take them to St. Mary's, but you're saying I'm going to Braeburn, and then St. Mary's is, let's say, 70,000 per term. Braeburn is 130,000. Then you can say that, okay, I'll chip in the 60,000.
Yes, this is between you and your ex. But if the court has to decide for you, they will not come down and look at the nitty-gritty details of how we are going to go about this. No.
The guy has said it is St. Mary's, it is St. Mary's.
Exactly. Now, it behooves you as the mother who doesn't want your child to go to a cheaper school to come and say, let's discuss. I can chip in. I know it's your responsibility, but I can chip in. Or we can switch responsibilities. Let me take school fees. You take what? Medical or something else. Yeah? And then we We move on with life. That's why I think a parental responsibility agreement, which the court will adopt, is better than the court deciding for you. The decision may not be favorable. It will look out for the interest of the child, but may not be favorable for you or...
I want to run back to the court and say, look, this kid was at St. Mary's at Brisbane, but now she's at the city council.
Yeah,
you know, and there is all this dust.
Adjusting.
And this man is saying that even though I have money, I want to chip in and take the child to St. Mary's. He has refused. The court won't listen to you.
So you see, because you cannot be forced to do beyond what you're able, which is also another problem, because there are some people who fake their income and they minimize it to make it look like they can't afford. Well, they can. This is just perhaps the spoils of war, the war they had in the divorce. And maybe the woman got some share that the man did not want her to get. And so he's thinking, now I need revenge, you know. It becomes about revenge and not about the child. So he says, oh, okay. So now she has taken all this property and she still wants this much in child support. I'm going to go to my employer and quit. So that I don't have a pay slip, I don't have an income. Then I'll go to court and I will probably get a very small part of the responsibilities, and this child will have to downgrade to fit. And I know she will not want that. So she will come back and say, no, it's okay, I'll pay school fees. And I will have won. You see, these are games that people play. Yeah? And so it's better when you sit down.
When you
and agree.
this thing is very interesting. Yeah? It's so nuanced because then at the point of divorce I might be jobless. The court doesn't look back.
It does, because children matters are perpetual. Meaning, if I was to file something today, I can always go back and review it. It will still be the same file until the child reaches 18. And even when the child reaches 18, I can still go and seek an extension because maybe they are going to college, they still need the support of their father. So it can always be reviewed. Even today, if we are given orders for, perhaps I'm told I'll get child support of 100,000 every month, and then 5 years down the line, the father gets a better job or the business does so well, I can go back to court as the mother and say, the expenses of the child have increased. We had 100,000 when the child was in primary school. Now the child is in secondary school. So we need more. The court will still review those orders and increase if it is available. A father who has the best interests of his children will not try to hide that or try to deny. If it is about the wife, you don't have to give the money to the wife. You can pay directly to the school if it's school fees. Pay directly to the school. Yeah. If it's about, maybe you are told to give a stipend for food, you can just go online, shop and let it be delivered to the house. If it's really about, I don't want this woman to touch my money.
Yes.
There are ways to take care of your children even when you don't have physical custody. Yeah. And as a mother, don't try to extort or, just milk this man dry. Think about your future. Because these wrangles you have now when the divorce is ongoing are not permanent. It's just a temporary phase. It's a season. Do you want to look back 10 years later and you're ashamed of the things you did, or your children are traumatized because of the process you took them through when you were going through divorce? No, you don't. So in as much as these things are happening now, look out for the best interest of the children. 10 years later, your children will say it was a difficult patch, but we are proud of our parents and how they handled us and how they handled the process. Yeah.
So what is alimony?
Alimony is like child support, but now for the wife. This is money for your ex-wife to sustain herself. Most of the times, alimony is requested when you're going through the divorce process. It will be one of the prayers. You will ask the court to give you alimony, maybe pending hearing of the main suit or even after. to be extended and the marriage to be dissolved or maybe to be given another chance to try again. Now, this can be defended in various ways. As a man, you can defend yourself by saying she's able-bodied. She's able-bodied, she can work and make her own money. Because some time back, alimony used to be given to ex-wives very easily, and it became a habit where women would make demands for alimony, yet they are doing well financially themselves. It would be making the other person a beast of burden for you. Marital obligations have been dissolved, but he's still your beast of burden. Every month he has to give you alimony. So this changed such that if you were not a dependent of this man immediately prior to the divorce, like for instance, you are not an invalid, you are okay, you are not a dependent, chances of you being given that alimony are very slim. They go reducing. You are of sound mind. You are healthy. You can go out there and work, make your own money. Your chances of getting alimony reduce even further. So you as the man, when your wife, soon-to-be ex, prays for alimony, that is how you defend yourself. Yeah, she's capable of earning.
Or you can say, I don't have it.
Even if you have it, you don't have to. You defend yourself. She's able to earn herself. I will provide child support, but not alimony. Yeah, and it's very clear. There's a clear distinction between the two. And so nowadays, alimony is not so common. You'll have to really prove why you need it as the one who, even men can ask for alimony. It's not just women who get alimony.
Do they really ask?
They don't. They're too proud, but they can if they wanted to. It's them who choose not to. But if they wanted to, they could.
And ask for alimony.
Yeah.
The kids, if the kids refuse that they can't be seen by either of the spouse that is not living with them at the time, then the spouse that has been given access has nothing to do.
Well, he can go to court again, but normally they go to court, they don't say the child has refused, because they usually imagine it's the mother who has poisoned them. So you as the aggrieved party, assuming it's the father, will go back to court seeking to find out why you are being denied access. So you'll file a notice to show cause as to why these children are not being availed to you. And there will be a hearing for that. So now in the hearing is when the mother will say, I've actually not denied him access. It's the children who have refused to see him for these reasons, and you state the reasons. And if the court feels it's necessary, they will speak to the children and find out why.
How do they speak to the children?
In camera, most of the times. You will be called, you'll be told to produce the children in court, create a very welcoming, less intimidating atmosphere in the chambers. This is now the office of the magistrate, not in front of people.
Yeah.
And they try to make the child comfortable enough to open up. So perhaps the man will be outside, even the mother will be told step out, and they speak to the child and find out what is the problem. And if it's established that the child was poisoned by the mother against the father, then action will be taken. But if the child is genuinely afraid or doesn't want to go to see the father, they cannot be forced. They cannot be forced.
So maybe this was a child that is a parent that was beating them, battering them.
Yeah.
And just the fact that he has left or they have left is now giving them a better environment. And then the court says that they should collect them again, and the children don't know where they're going, and they are not interested in going.
Yeah, yeah. And sometimes even a court that is has had a lot of experience with these things can tell this child needs therapy, this child needs counseling, and it can be the parents can be asked to provide that, because sometimes a lot of damage is done to children in the process of the divorce unknowingly. And sometimes the damage is done during the marriage, like now that in the name of discipline, maybe the father was very violent. And by the time you're separating, the children want nothing to do with you. Yeah, they need help with that, to come to terms, to process, to heal. That can be availed to the children. Hopefully it will mend the relationship between that parent and the children, and then they can have access.
At what point are you obliged to provide for the children? The children are 18. Is that the cutoff for the in the eyes of the law?
Yes, it is. However, if they are still dependents and they still need child support, you can now say you'll apply for those orders that were given before to be extended. Yeah, so there have to be orders first, then you apply for them to be extended. Maybe because they're in college, they need school fees, they don't have a job, they still need to stay in the hostels, they need rent and things like that. However, if you're just okay, you're not a dependent, but you're 19, then that's the end of the child support you've been getting. And I think some of these things we don't need to go to court for them, because if your father has been taking care of you all this time, it's because they love you. They want the best for you. It's very easy for you to go and talk to your father at 18 and tell him, I still need 1, 2, 3. Any loving father who wants the best for their child will continue providing it, not because they're compelled by some order somewhere, but because they genuinely are interested in giving the best to their child. Yeah.
Okay. Do they have to go to court and apply to access the children, either of the spouse? In your experience, do people refuse access to their ex-spouse?
Because most divorces are acrimonious, they do because you live with your children and you don't want anything to do with that man. People tend to want to pitch camps and people to support them or feel sorry for them, and unfortunately the children get mixed up in that. So if the mother has gone with the children, she'll want the children to side with her, take her side, support her decision to whatever she's doing, which is quite unfair, because I think the relationship that a mother has with her children is different from the one she had with the father of those children. And children need both parents, irrespective of what's happening between the two of them. And they can clearly see for themselves. And it's such a huge burden to put on children to choose between their two parents. But what I've seen is that is happening. It's very common. It happens that one has to go to court to actually ask to access his children. Yeah. But for the few who are still cordial, did not break up or divorce badly, then it's quite easy to co-parent. And also, there are people who have children without having gone through divorce because they were not married anyway. They can still co-parent, Just agree, this is our child, we are no longer together, the child doesn't have to suffer for our misgivings, let us do the best for them. Fine, you agree, I'll give you access, you don't have to go to court for that. And you give the access.
What about if I am a mother and I'm saying that I want to remain in the matrimonial home? I want the court to compel the man to leave and leave us here, even though the house is not matrimonial property.
All right, you can apply for that. At the end of the day, you'll have to show why, and if you can get the orders. For instance, if let's say he's violent and you want to go get a restraining order based on his violence, and you want to remain with the matrimonial home because of the children or whatever other reasons, you can actually get it. Now that is a completely separate application, not in the division of the matrimonial property suit. The division of the matrimonial property suit goes according to contribution or the agreement you had before. But then again, if there's an abuser or a narcissist involved, it's rare that there will be an agreement. You have to actually go and fight for it in court. Yeah.
But then if it is not matrimonial property, it is on the other spouse's name, but the other spouse is living in it. For how long I decide I want to sell it, I can't sell it because the court has compelled me to let the children and the wife stay in it.
All right, maybe I should clarify something. Even if it is in his name, it is still matrimonial property as long as it was acquired during the subsistence of the marriage. So if the lady moved out, maybe for her safety and protection, left the man in their matrimonial home and went and filed for divorce and actually got the divorce, but did not file for division of matrimonial property, and now is here wondering, how do I get him out of that house so that I can get back in? It is quite tricky, because where do you even start if not going to file for the matrimonial property suit?
Yeah.
Yeah, it's easier if he left, then you can keep him out. But it's you who left.
You apply for a restraining order.
Yes, but if it's you who left, how do you come and get him out of that house? It's tricky. Go and file a matrimonial property suit and let it be determined by the court. Yeah, and if then during the process you can reach an agreement, well and good. If you can't reach an agreement and you get your apportionment, and maybe yours is bigger, he can buy you off and you get your house. If his is bigger and he buys you off, perhaps the amount you'll get will enable you settle elsewhere. Yeah, but these are the battles that we fight for years in court. Matrimonial property suits can actually go on for quite some time. Yeah.
But how about when there is a lot of family involved? I see women mostly who their spouses die suddenly, and the extended family, especially the immediate family of the man, are coming and saying this belongs to our son. And I see a lot of that. I think we have all read it in the newspapers.
Yes.
How then does the court? How do they? Because what is not matrimonial property? And the owner of that property is deceased. So, for example, I have, we were talking about tracts. I have 25 tracts. In the prenup, it says very well that these are things that I came with into this marriage. The mother is saying that I supported my son before he got this woman, and he has been building this thing, and we don't feel that all this property now should go to the wife. How does the court make a pronouncement on this?
Okay, so when there is a deceased in the picture, it is now a matter of succession and inheritance. So you have to go and file for probate and administration, how the estate of a deceased is going to be distributed. And this has nothing to do with whether you are a wife, or whether you are mpango or kando, or whether you are a dependent, or whether you are a child. It's a completely different process that goes with the Law of Succession Act, no longer the Marriage Act. So under the Law of Succession Act, there are those people who are at the very top of priority to apply for that, and the wife comes at the very top before the parents of the deceased. Yeah, so what this woman should do, this widow should go and file to be given those letters of administration or whatever grant, whatever she's applying for, depending on the circumstances that are there. And if there's anybody who is contesting that, they can go ahead and do it in court. Yeah, and then the determination will be made by the court. Most of the times, the deceased passed on without a will that is intestate. So the decisions are left entirely upon the court to decide, and it will decide according to the facts that are provided by the parties that are involved. However, if there is a wife, she will be considered for the close, the things, the household items, the car they used to use, and these ones that are close to the family, the children as well. But if the children are minor, she will hold them in trust for the children until they get to age of majority. If there are dependents, for instance, now the mother-in-law, if she was a dependent, like maybe medical, she has, you know, the old age conditions, and her son is the one who was taking care of her just before he passed on, she will still be catered for by the estate of the deceased. But you can't just come and take, you know, the way they come and sweep the house clean, that is wrong. But the woman doesn't know. Most of the times they're ignorant about the law. So they don't know, and they look at the traditions more than they look at the law. It's important as a wife to know where your husband's documents are. Yeah, his ID, such that when he passes on before you, you can be able to go and apply for the death certificate before other people come and meddle, so that you can go to court. There will be administrators whom, I always say the best way to do this thing is to sit down and agree, all interested parties. But the truth of the matter is, it's not always that way. The ideal does not always apply. People will come and fight. So the moment someone is coming to the lawyer, they're already in trouble. The in-laws already came. They already swept the house clean. They took title deeds. They did what? Come and help me. So now you go to court, you find, oh, actually we are going to contest an application that has already been filed. Why didn't you file? I was grieving. I didn't know. I was confused, you see. So it's always better to plan your estate in advance before. Don't do it on your deathbed. Yeah? Plan your estate in advance. If it's about the marriage and you're foreseeing, you know, something coming up, plan in advance. It will save you so much, and your people who you might be leaving behind.
But then, does the police, when you have, for example, a restraining order against your brothers-in-law, how does the court actually make this happen? What do they do for you when they, for example, your brother, the two brothers-in-law, you know, keep coming to your house and they want to break through the gates, and they're doing this thing, and they've been giving a restraining order, and they don't want to listen to the restraining order or abide by it. What is the next step that you do?
Execution is a whole other different process, because you can have orders, but how do you execute them? So you find you're just peacefully in your house and the brothers have come, they've broken the gate and they're coming in forcefully. The first thing you do, call the police. They don't come. Have you ever called police and they came? So you'll call for help from wherever. Maybe a friend who will go get the police from the nearest police station and come with them to quell the situation.
And then show them that this is a restraining order, that they are not supposed to be in this compound.
Exactly. And then now when everything has come down and people are safe, now you go back to your lawyer, who goes back to court with this order. And now it becomes a whole other different.
But don't you think it's also criminal to badger into somebody's house? Can you also involve the police to look at this as a criminal matter and not really as an estate matter?
Exactly, that's what happens. You'll find that there's this one, the estate matter going on, and a criminal matter going on. Even in division of matrimonial property, you'll find we have that case in the High Court, and we have a criminal one in the criminal.
Somebody vandalized a property somewhere.
Yes. Like I have a situation where a man bought a piece of land, but the woman came and developed it. And then now when it came to divorce, the man came with a bulldozer and demolished everything.
On his land?
Yes, on his land. Like, I want my land back. So he came and demolished everything. So the tenants who are there also are aggrieved. The wife who put up the structures is also aggrieved. So they have also gone and reported vandalism and all that. And there is a criminal case going on. Meanwhile, I'm handling the matrimonial one in court. Unfortunately, this happened before we got injunction, so there was nothing stopping him from doing this apart from maybe his moral compass, which he did not use at that time. Didn't even care about the loss that will be occasioned upon the tenants who are innocent. They are not part of these marital squabbles. Yeah, so there'll always be, you have to follow up with the cops. Report, they will press whatever charges, and it will proceed in the criminal court.
It can be very chaotic.
Chaotic and messy and complicated. Yeah, especially when you find I'm not a criminal lawyer myself. So you've come to me, I'm handling your matrimonial property suit. And then you come and tell me your property has been vandalized and I have to get you a criminal lawyer. So you have the divorce, the matrimonial, the children, and a criminal, 4 different cases going on at the same time. Why?
Wow.
It's not necessary. If you could just
That's
calm down a little bit.
I think one of the things I've learned from this, Christine, is that there's a lot of we shouldn't be afraid of pre-planning these things.
Exactly.
The prenups.
Yes.
It's a possibility.
It's a possibility.
Only the sun will always rise tomorrow.
Yeah, and think about it this way. You didn't want to sit down and do a prenup because of your religion. Now you've gone full cycle. Unfortunately, you are at this point of divorce. You have all these cases. All of them are acrimonious. You cannot see eye to eye. You have inherited enemies. Where is your religion at that time? The same religion that you used as an excuse not to preempt, where is it now? Yeah, because when you're going through these things, people forget about logic. They forget about their morality.
It's very strange how religion, creeps into everything. Because even yesterday I was having a very heated conversation about polygamy and monogamy, and religion finds itself at the center of it. The divorce, religion is there.
Yeah.
Everything revolves around religion and a little more of that. So I want to say thank you very much for this series. I'm thinking we will talk about something else, but this comes to the end of the series, the part 3 of it, and I thoroughly enjoyed it. And one of the things that podcasters, I believe, and get from doing podcasting is learning from so many people. Yesterday I was talking to a psychologist, I was talking to the lawyer the other day, then I'm talking to this, I'm having a conversation with a traffic control commander. You learn so much, and the crazy things he was telling me about planes and how they land and how you can see them wanapangana hivi. So a lot of things. So thank you very much.
You're welcome.
And I wish you the best in your career, right?
Thank you. Thank you.
So people of the internet, thank you very much for listening in, viewing, seeing what Christina has to say about marital law, about child custody and things like that. I hope you can if you like the channel, please leave a comment. Talk about your situation that you've seen, what we did not talk about, what you'd like to be discussed, and I can always give Christina a holler and say, okay, people are asking that we should be talking about this, but also please subscribe to the channel, and hit on that notification bell. So until another video, thank you and see you.